Good morning, everybody. Welcome to the MSc and Employment Landmines Amid COVID-19 webinar. I'm your host of the day, Lucy Minde, and I'm glad you could join us. If you're joining us from Zoom or Facebook or YouTube, Karibu. In order to allow more people to log in, we'll start off by introducing myself and the Tanzanian associate, and also my co-host will also be introducing herself. My name is Lucy Minde. I'm a legal consultant at the Tanzanian Associate Limited, an advocate of the High Court. The Tanzanian Associate is a social enterprise that provides different innovative solutions to Tanzania. We exist to provide legal innovative solutions to startups, MSMEs, and the legal profession in the country, and we strive to make legal information easily accessible and help businesses comply. Today, I'll be joined by my co-host, Angela Ndolwa, all the way from Nairobi, who will be moderating on behalf of the Africa Law Tech. So Angela, please could you introduce yourself?
Good morning, everyone. I'm Jamboni all the way from Nairobi, Kenya. My name is Angela Mwadumbo. I'm an advocate here in Nairobi. I'm also from the Africa Law Tech Association. This is an organization that brings together legal tech startups all over Africa. So you're free to join us. Then before we start this webinar, there are some few house rules that I would like all of us to know. First of all, if you are welcome to ask questions all through the presentations, but please make sure you ask the questions on the question and answer section and not on the chat section. When you use the question and answer section, we are in a better position to track your questions, and the panelists can even type the answer there. Then we are going to keep all your mics muted apart from the person who is speaking, of course, to minimize on the background noise. Then all through the presentations, there'll be polls that will be running. So we encourage you to participate in the polls. Then at the very end, there'll be a survey, just a quick survey. After you leave the meeting, there'll be a pop-up survey. We also really encourage you to just take 2 minutes of your time and participate in your survey. So we have a very interesting array of speakers. So over to you, Lucy.
Yes, so just a bit of an introduction on why we're doing this webinar. Like many businesses, we were basically looking at what are the challenges that SMEs are currently facing at the moment. And after doing a quick survey with some businesses, we identified there are some key challenges. And the challenges were initially on employment law. So we thought we should organize a webinar where we can get the key stakeholders and representatives of the different organizations to walk us through some of the pitfalls that we should avoid during this time. We are glad to have all the stakeholders on board, and we're going to be having representatives from the ILO, ATE, TUCTA, and the CMA. So without further ado, I will be introducing our first speaker.
So our first speaker is Mr. Maridadi Fanuel. He is the National Program Coordinator, Governance at the International Labour Organization, that is the ILO. In his role, he manages the Improved Labour Market Governance and Promotion of Tripartism Project and ILO activities that feed into the democratic governance, human rights and gender equality outcome of the United Nations Development Assistance Plan. Specifically, Mr. Maridadi's role includes advising and supporting the government of Tanzania and employers and workers' organizations on labor law, labor inspection, social dialogue, and international labor standards. So before Mr. Maridadi gives us his presentation, we have a short poll that will pop up on your screen. And the poll question is, are you an employee or a worker? Please note that there's a difference between an employee and a worker. And do you have employees or workers in your business? Kindly take just 20 seconds to vote in the poll. Then Mr. Maridadi, over to you.
Thank you. very much, Angela, for the welcome. I take this opportunity to greet all of you participants and the moderators. Good morning.
Good morning.
Kindly please vote so that we know the results, whether you're an employee or a worker. And hopefully the results will be displayed. Okay, we have 74% saying that they are employees, and 13% saying they are workers, and those who said that they don't know, they are 13%. The way I see now, we have 35 participants, so it's a good number. Now, we will be in a position to understand the difference between the two, whether you are an employee or a worker, and whether in your organization you have employees or workers. Therefore, I propose that the presentation be displayed so that we can follow up as I proceed with this presentation. Thank you very much. Essentially, can you go to slide 2? Essentially, in order to be in a position to understand whether you are an employee or you are a worker, you have to see or you have to understand exactly the employment relationship. Employment relationship, which means the performance of a contract of employment by the parties to the contract, is the one which creates an employment relationship, and therefore for a person to identify himself as an employee. Normally, the employment contract, which creates an employment relationship, has two parties, the employer and the employee. The employer is the person who employs an employee. It may be a natural person or an artificial person. While an employee is a person who has engaged or has entered into a contract of employment with the employer. Therefore, for a person to have that legal relationship as an employee, you must be an employment relationship under the employer-employee relationships. What about workers? Workers, there are some workers who are working for people, but they don't fit completely under the criteria needed for an employment relationship. Take, for instance, a person is doing short specific tasks, and they get paid at that very moment, and then the relationship ends. As I proceed, you will come to realize that most of the essential elements which build this relationship do not exist, and therefore very difficult for them to be categorized as employees. Therefore, very briefly, every employee is a worker, but not every worker is an employee. For a worker to be an employee, you must be under the employment relationship and being bound by the terms and conditions of the employment. Then, if under the employment relationship, you must take note that, for instance, for those who are working under MSMEs, which most of you are coming from, the thing to note is that we as ILO have the international labor standards, which I will speak later on. The international labor standards protects both workers and employees, workers in broad terms, because we protect both workers, even those in the informal economy, even those who are working in arrangements which are challenging in this time, including in the gig economy, including those who they don't have contracts of employment, and all categories of workers, including self-employed workers. That is why the ILO uses the terminology workers in broader term to cover all them all. But when we talk about the labor laws of Tanzania, that is the Employment and Labor Relations Act, as revised in 2018, the relationship that exists is that of employer and employee. Now, under this relationship, you will take note that there are duties and obligations which attaches to the parties to the contract. On the part of the employer is bound or is required under the employment contract to adhere to certain obligations, to comply with certain obligations. One of these obligations is to pay salary. Normally, an employment contract is based, if services are rendered by an employee, automatically at the end, the employee must get some sort of consideration in terms of payment. Therefore, employer has an obligation to pay remuneration. A second obligation of the employer is to provide tools of work. For instance, under this challenging time, if, for instance, you are working from home, you are teleworking, employer is supposed to provide you, maybe if it's the laptop, so that you may be in a position to do your activities at home, so that you are in a position to render services in accordance to your contract of employment. I understand that there are challenges. Some workers are required to be based in the office, but we as ILO now, we are advised employers that to consider teleworking, especially for workers who are not very critical, so as to try to minimize these cases of COVID-19. Then another obligation of the employer, of course, is to honor employees' rights, including issues relating to leaves. Employees have the right to go to leaves, and annual leave, sick leave, paternity leave, maternity leave. Employee must honor all these leaves. Issues relating to freedom of association. Employees should be given a right to join and participate in trade unions of their own choosing, including also honoring working conditions. Therefore, these are the obligations of the employer. On the part of the worker, there are also obligations. The most relevant or the primary obligation of a worker is just to render services. If you don't render services, for instance, if you are teleworking, according to instruction given by your employer has the right to deduct your salary depending on the number of days you didn't provide service, because consideration has to be made depending on the services you render. Therefore, that is key to note. Also, an employee has to respect the employer, because the employment relationship must have some sort of respect, and that is how a contract of employment can be performed. And also, an employee is not supposed to disclose confidential information of his employer. These are the obligations and the rights which accrue to both parties. Now, whether these obligations extends to people who are teleworking, yes, they do, because the employment relationship still exists, even if you are not in your duty station, you are teleworking from home, but still these obligations are attached to you since the employment relationship still exists. One of the questions that you may be asked, or which the issue that is very important, which you should take note of, is that under the Employment and Labor Relations Act, an employer must issue to an employee a contract of employment. And according to the amendments that have been made to our labor laws, then whether an employee is working in the United Republic of Tanzania or they are working outside, then the contract has to be reduced into writing. That is the requirement of the law. If an employer has not given an employee a contract of employment, he is required under the law to supply with him with the written particulars, with the written statement of particulars, including the remuneration, how it will be calculated, leaves, hours of work, and all of these working conditions that relate to the contract of employment. So essentially, that is a contract of employment. The following slide, please, the next slide. Thank you very much. The second part of my presentation is the ILO's policy on occupational safety and health. Participants, you will agree with me that COVID-19 pandemic has affected many enterprises, including the MSMEs, under which most of you are working. Since most enterprises are affected and most workers or employees are losing their jobs because of the reality, the ILO has come up with a checklist on occupational safety and health to ensure that employers are developing, for instance, the policies in consultation with workers at this critical time. If you see at the bottom of this presentation, at the bottom of this slide, there is a link that I have provided that provide a document on the checklists that the ILO has developed for employers to ensure that the workplaces are well organized in consultation with workers to ensure that the lives of workers are secured at this critical time. This resource document may be provided later on in PDF for those who may be in need. Essentially, the ILO Occupational Safety and Health has a list of fact checklists or issues that have to be taken into consideration by the employers in consultation with the employees at the workplaces. First, the checklist provide for planning for an office, reorganizing it, taking into consideration the changes to accommodate COVID-19 pandemic, the changes that have taken place. So planning, then developing the policies, then preventive measures, and lastly, consultation with the relevant authorities, for instance, in issues relating to individuals who have been identified to have contaminated the disease or to have been affected, on how they have to be helped, for instance, taking them there in consultation with the relevant authorities, government authorities, hospitals, etc. Therefore, I will mention, for instance, very few issues that have to be taken care by the employers in consultation with the workers. One of them is to develop a preparedness and a response plan for COVID-19 prevention at workplace, ensuring that all workers are consulted through their unions, the employees through their unions, and the workers, if there are workers who are affiliated to unions, then they have to be consulted in this preparedness and all response plans, and in the decisions which the employers are making, so that you are at one page when you are moving on with your contract of employment and this relationship. Secondly, the employers are advised to make the hazards of all operations and covering all jobs, the operations, if for instance, industries, if for instance, you are doing businesses in enterprises, how do you measure the hazards and the risks, for instance, of workers who are traveling? You know the risks of traveling now, you may get contaminated. You should avoid traveling which are not relevant. This is very important. Thirdly, the employer has to promote teleworking, which I have already mentioned before, so as to minimize the spreading of COVID-19. And also, the employer in consultation with the workers is supposed to develop a plan of what to do if a confirmed or suspected case of COVID-19 is identified at the workplace. And another example is that employer has to consult with employees and provide staff, customers, and the visitors of the employer with ample and easily accessible places where they can wash their hands with soap and water and disinfect hands with the sanitizers and take all measures which are necessary to ensure that the safety and health of workers and those who are coming to their offices are safe. Therefore, to summarize this part, what is key is that in developing these policies, in consultation with the worker, in developing these policies, employer has to consult. Consultation is key, especially at this critical time. Consultation is key because when you consult, I am very sure you will come up with mutual agreements which will be very beneficial to the organization and therefore be in a position to ensure that at the end of the day, the employer and the workers will be able to succeed this pandemic and therefore restore to the original position. Therefore, a document in PDF will be shared later on. The last part of my presentation, if we can go to the next slide, please. The last part of my presentation is about the ILO's support. You must take note that participants and my colleague presenters, the ILO is formed by the tripartite constituents. That is the government, the employers, and the workers. The ILO is the only tripartite agents of the specialized agents of the United Nations that works with these three constituents. Therefore, in everything that we do, in planning, in developing the policies of the organization, in supporting our constituents, we provide support in consultation to all the tripartite partners. That's why, for instance, when we are having the International Labour Conference, you find that the government representatives have to attend together with the representatives of workers and the employers organization. Therefore, that is a key point I should mention from this slide so that you understand that our support is to the government, to the workers organization, as well as to employers organization. Normally, our main support at this critical time of COVID-19 is to conduct research, to publish relevant materials and share the knowledge. For instance, apart from the document that I have mentioned, the checklists, which are very important for employers and the workers to help them at their workplaces, the ILO has developed a document, has published a document that is International Labour Standards on coronavirus, very specifically on coronavirus. You know, the ILO has 402 International Labour Standards so far. We have 190 conventions. We have 206 recommendations, and we have 6 protocols. Therefore, if you take a total of them is 402. And among these, we have picked those relevant standards which answer all questions you may have on issues relating to COVID-19. For instance, if your employer is proposing to take you home without leave without pay, you can get answers to ILO standards relating to remuneration, which are under the document, under the link provided. Also, if, for instance, there are the procedures which can be used to ensure that there is consultation and a discussion to to agree on the issue forward. So therefore, that is a key issue that you must take note of.
Mr. Maridadi, we lost you for some few seconds.
Okay.
When you were, immediately after you were saying about the issue of remuneration,
Exactly.
we lost you for some 30 seconds there.
Okay.
Maybe repeat that bit for our participants.
Okay. The issue is COVID-19 has affected many workers. Some of them are being sent at home, at leave without pay. Some of them, the proposals for salary reduction has come up, but the ILO standards provide for answers on all these issues, on how you can dialogue and extend leave to paid leave to employees at this critical time, or how you can consult on issues relating, for instance, to the issues that you are saying that, or that the employers are proposing, some of them are proposing on salary reduction. The key issue is that under social dialogue, which the ILO promotes, consultation is very key. If employers can sit with the trade unions and their employees and agree on these issues, then that is quite fine. Otherwise, if you read the Employment and Labor Relations Act, specifically Section 15 of the Employment and Labor Relations Act, subsection 4, an employer cannot change a term of the contract and the contract to employment without consultation. Is contrary to the law. That's why the answers are provided under the standards, and therefore consultation is key if the terms of the contract have to be changed. To conclude my presentation, we are providing technical support to build the capacity to build resilience, to rely on resilience, because we have to bear one another. This is a contingency issue which no one anticipated it. And take note that this pandemic and other pandemics, they are not addressed by the Employment and Labor Relations Act. That is why consultation is key. And the ILO will continue to build the capacity of the tripartite constituents at this critical time to ensure that you reach mutually to the
Mr. Maridadi, we lost you again, but I think he had already concluded he was concluding his presentation. So over to you, Lucy, once more, as we are working on Mr. Maridadi's audio. Over to you, Lucy.
Yeah, thank you very much, Angela, and thank you, Maridadi, for an enlightening session. I believe most of the participants' questions have been answered in the importance of contract and mutual consultation. Without further ado, I'll be introducing our second speaker from Susan Ndobwa from Association of Tanzania Employees Association, and she'll be taking us through stuff. So just to start off with, Susan is an advocate of the High Court of Tanzania. She's got extensive experience in employment and labor relation matters and criminal prosecution. She has worked with the Attorney General's Chamber and served in different institutions like the CMA as a commissioner and a non-executive in government institutions and private companies. She will be taking us through a poll to kick off her session. And her question will be, how many of you know about the Association of Tanzanian Employers? So you have 30 seconds to answer this question. If you do know or have heard of the Association of Tanzanian Employers, please vote I do. If you don't, say I don't. And if you have no idea, vote that you don't know. So we'll give you 30 seconds. After 30 seconds, the poll will disappear from your screen. So please vote so that Angela can be able to take us through this. So Angela, karibu. We are glad to have you on board.
It's actually Susan who's giving the presentation. Susan, karibu sana.
Sorry, Susan, I apologize. Susan, karibu.
Thanks, Lucy. I thought that Angela was taking up my presentation.
No, it's you. You cannot.
Yeah, thank you. Okay, I see the results have come in. We have 62% of the participants say that they are aware of the Association of Tanzanian Employers. And 29% do not know, and 9%, no, 29% they don't, and 9% they do not know. At least 62% do know. So it's my belief that after this presentation today, the 29% will know about the Association of Tanzanian Employers, and those who are under the 9%, those who have said, I do not know, they would also know. So at the end of the presentation, we'll have the 100%. Thank you. Can we move on, please? As Lucy introduced me from the Association of Tanzanian Employers, the head of legal services, and I'm very glad to participate on this Zoom meeting to speak to the SMEs. And I would like to touch on guidance for the workplace in lieu of the COVID-19. And the first presenter, Maridadi, has spoken very well, and some of the points that he's touched, they will also come under my presentation. I will just repeat where I can, or even speak more about it. But I just wanted to appreciate his presentation because it has covered a lot, and as far as the international labor standards are concerned. But since the outbreak of the pandemic, we as the Association of Tanzanian Employers, where our mandate actually is to advise employers on employment and labor matters, making sure that the business environment in Tanzania in respect of employment and labor is very, very conducive for employers. So as Maridadi said in his presentation, these are unprecedented times. The Employment and Labor Relations Act has not covered a lot of things. I mean, and to be specific for this Zoom meeting, issues of webinars. We have had employers coming out to consult on different aspects that I would like to speak to you about. Issues of health and safety matters that have come during these times. What are the obligations for employers and the employees as well? And Maridadi has touched on that. Issues of working from home. As we are very much aware, since the COVID-19 is a health matter, and most employers have sent their employees to work from home. So there are issues around working from home as well that we'll be looking into. Issues of workers' compensation. What are the measures in case of loss or reduced business? The businesses have been lost. Employers have not been able to do business. They have lost business all over the place, and some have reduced and they have to close down. Some had to reduce their working hours. And what should employers do during this time if you've lost business? We'll speak about. But what about employees if they get sick? What does the law provide? We are going to look into matters of leave, paid leave, unpaid leave, sick leave, even compassionate leave, in case that an employee has a family that is not well at home, or themselves if they're not well, or they have lost somebody at home. Maridadi also spoke about salary reduction. In order to sustain business, some businesses have proposed, and they've been actually coming along and ask about salary reduction. Can they reduce salary? And retrenchment. I would like to hear from the participants as well if there are any retrenchment that have been going on at their workplaces, and if some of the participants are employers, how many of them have retrenched their employees and how have they done it? but also speak about social dialogue. Maridadi has spoken very well that social dialogue is the solution to many problems. It is about consultations. And what about amendment of workplace policies? So just to go back to what are the obligations of employers and employees at the workplace during this time? As we have seen that employers have many obligations. And one of the obligations is on health and safety matters is to make sure that reasonable, practical health and safety measures at workplace during these times, as we know that the COVID-19 requires health and safety measures, washing of hands and making sure the surroundings are clean. So, unfortunately, our laws, the Occupational Health and Safety Act of 2003, Section 95, provides for employers' obligation when it comes to health and safety measures. And to be specific, when I will just mention some of the provision, it provides for employers to provide instructions, training, and supervision necessary to ensure health and safety at work for the employees. So even during this time, this can be extended for the employers to train the employees about health and safety measures, to ensure that they take precautionary measures, to conduct their undertakings at a very in a safe, on a reasonable, practical manner, as we know that COVID-19 can be transmitted, through touch or what, but issues of cleaning and health is the most important during this time. So employers are supposed to making sure that the workplaces are clean. And we've seen that the government directives, the Minister of Health has been issuing different government directives about washing hands, keeping sanitizers at workplace, and the social distancing. So these are the same measures that employers need to make sure that they take in consideration. I do understand that we have different workplace and we have different spaces at workplace. Somebody asked me a second, my space is so small and people sit, they cannot maintain 1 meter, or what can I do? Some employers have come with the solutions. They do work rotations. They've done that. They do work rotations so that not many people are in one office at the same time. And if somebody has some flu symptoms or anything of that suggests the symptoms of COVID-19, some employers have an isolation office where somebody can sit by themselves, but maybe if somebody portrays those symptoms, it's best that to allow them to work from home. So now that brings us to my next point about working from home. Most employers have been asking about issues of working from home. There has been also disciplinary issues along that working from home, because employees are supposed to log in, some log in and they do not perform work. Some have issues with equipments, and Maridadi has spoken about equipments. Employers should provide equipments to facilitate employees to work from home. Issue of performance, businesses are different. There are certain businesses that their work can be performed from home, but some businesses probably not every role that an employee can work from home. So I cannot provide what kind of a guideline can be used there, but the reasonability and the discussions between employers, and the most important point, the supervisors and their employees, they should speak on how they can manage so that work can continue. Because at the end of the day, these are difficult times. We all need to perform and making sure that businesses continue. So working from home, but in order to solve the big issue that has been coming out about working from home, as we say that, but working from home has become a new normal now, and I don't know, maybe it will continue for quite a while. Businesses have been tested. They have seen that some employees can perform better when they are at home, because they can take care of their families and then they can have time. Some cannot perform better at home. But what kind of policies should employers have? And this is the question that I'll come back to ask you in the end. How many of you have got working from home policies? Some employers have, but many do not have, and most of them, they have been consulting on this one. How can we make a working from home policy? What are the issues that we should be considering? The issues of workers' compensation, You know, when an employee is working from home, how should an employer making sure that the employee is safe at home? And would you consider a home or an employee's home to be a workplace, or what kind of work? So there are many issues that, but I would like to discuss about some of the measures that have been taken. Issues of leave. The question has been, employer has lost business or reduced business. What kind of leave should you provide? Should you provide paid leave? Should you provide unpaid leave? Okay, we have no problem with sick leave. If somebody is sick, this is something we have practiced before, that the Employment and Labor Relations Act provide for sick leave of 126 days, you know, in the cycle of 3 years. So that one, I do not think we have a problem with that. Compassionate leave, you have 4 days, but employer's policy can provide more than that, because as we know, COVID-19 can take up to, compassionate leave under the Employment and Labor Relations Act, it is 4 days. But for somebody to get better, if you have been affected by COVID-19, probably it takes, if they say the symptoms, they can show up within 4 to 7 days, probably it's more than that. So we look into employers to amend their policies, or at this time also to be very, very flexible, because the situation that has come about, it's not something probably most of us have faced before, because I don't know when was the last time was the last pandemic. So this is quite new. But there is paid leave. Employees, they accrue paid leave every year. And a paid leave is 12 months in each year. I mean, it's a cycle of 12 months, but you are getting 28 days. The law says 28 days consecutively. This is a paid leave where an employee is at home on leave, but the employer is paying salary. So there is a different misunderstandings between working the days that are working days or consecutive. If it is consecutively, it includes the weekends, it includes the public holidays as well. But if an employer's policy excludes the weekends or the rest days, then you only count on the working days as per the business. If you're working for Monday to Friday, yes. If you're also working on Saturdays, like some of the businesses like banks, that is also considered as a working day. So there's an issue of unpaid leave, and Maridadi has spoken about it as well. Unpaid leave has not been provided under the Employment and Labor Relations Act. But with consultations, we at the Association of Tanzanian Employers, we have been telling employers, we've been advising employers that before you consider retrenchment, before somebody loses a job due to the pandemic or loss of business, it is best that to look for the alternative, because the law, when you look at Employment and Labor Relations Act, it provides for alternatives or the measures that an employer can look into in order business is not lost. And unpaid leave is one of them, because when things go back to normal, or when they start going back to normal, employers can start returning some of these employees back to work. And if you have given them unpaid leave, then at least these employees have not lost jobs. So this is something that we really advocate for unpaid leave. But employers should not take this decision alone, unilaterally. It should be bilateral arrangement. Consultation with the employees, they should sign the form that they have agreed to take the unpaid leave. Because I'm sure the other speaker from CMO will be speaking about disputes that will come out of this. So it is very important that to make sure that consultations are conducted at workplace in order to minimize the liability for employers. That goes hand in hand with salary reduction. As much as Section 15 of the Employment and Labor Relations Act provide for terms and conditions of employment contract to be changed or amended by the employer. But there is there's a word say this decision should not be taken unilaterally, meaning the Employment and Labor Relations provides that employers must consult with the employees when they change the conditions of terms and conditions of employment contract. So it is very important to make sure that employers follow that. So they should ensure they are explained to the employees in a manner and that the employee would understand. So anything that the decisions that employers would be making at these times, you know, and if it is not provided by the law, it is important that employers should consult with employees. I would like to speak more on the retrenchment. And when we talk about retrenchment, as I said before, retrenchment should be the last thing that employers should consider. And there are reasons, you know, the Employment and Labor Relations Act provides for reason and procedure in case of termination. For termination to be fair, any termination under the Employment and Labor Relations Act, it should be first fair, and also it should follow fair procedures. So when it comes to retrenchment, it should be fair. What will be the reason for that retrenchment? For the pandemic would be, employers will have different reasons. So I'll make an assumption of COVID-19 has affected business. So economic situation could be one of them. Technological change, maybe an employer has come about with a new technology that instead of having 10 people to perform a certain job, maybe 2 can do that. That could also, but the structure changes. Maybe some employers now, they are thinking of changing the structures that I do not need to have this amount of employees. Maybe I need to change the structure. The management should be different. This and that could also be a reason. But if it is economic or financial constraint, could also be a reason, and probably at this time, that is one of the reasons that most employers are conducting retrenchments. But after you have a good reason to retrench, and you have the documentation to justify, employers should follow the procedures. What are these procedures that are provided? Consultation. And I will repeat, I've been repeating issues of consultation from the first presentation towards the end. You hear a lot of times I'm speaking about consultations, because, and especially on retrenchment, if you have a trade union at workplace, you must consult the trade union. So the employer must have consultations with the trade union. If you do not have a trade union at workplace, then the employer should consult the employees who are going to be affected with the retrenchment. So these consultations, they come in different forms, and people get confused. How many times should I consult? Do I need to get probably 2 or 3 months? The law says you provide the notice for retrenchment to the employee as soon as the retrenchment is contemplated. As soon as you know that you are going to conduct a retrenchment, the employer should issue out the notice to the employees to inform them that the employer wishes to inform the employees on the retrenchment procedures. That is just a general consultation. General consultation should not point out, say, Lucy, you are leaving, or you know, certain employee you are leaving. No, it is just a general consultation. Then after, that is a general notice. Then after the general notification to the employees, then the employer should start consulting, whether with the employees or the trade union at workplace, where they will be discussing the selection criteria, who is leaving and to why, is their position not needed anymore, or if it is a reduced work that I do not need 10 people at this time, probably I just need 2 people to manage the business until the pandemic crisis is over. You know, that can be discussed in this meeting. But the point I want you to take away is consultation, making sure the selection criteria, but also the issues of benefits. What kind of benefits are being provided, terminal benefits, when an employee is being retrenched? What are the benefits? When you look at the Employment and the Labor Relations Act, these are 80 small pocket size, the law, the Employment and Labor Relations Act. When you look at the Employment and Labor Relations Act, on the issues of retrenchment, the law has been very lenient to the employer, because you look, why is an employer doing the retrenchment? Probably it's because of the economic reasons. So therefore, the terminal benefits that have been provided by the employer includes the remuneration. I'm sure at that time the employee has been working over the last month of remuneration. If there's any leave that an employee has accrued, you know, has been earned and not paid, the employer will have to pay for that leave, will have to pay for any notice pay due. If an employer has not consulted the employee for the period of 30 days, because the notice, if the notice for any termination, if you're paid monthly, is 30 days. So therefore, you should give out the 30 days for the consultation period. However, we insist that as soon as the employer contemplates the retrenchment, it's good to give that notice. So if you have not made the notice of 30 days, then you must pay for that notice. But it also provides for severance pay. Severance pay under the law, it is 7 days for each year an employee has worked, to the maximum of 10 years. So even if an employee has worked for 15 years, the cap will be 10 years. 7 days for each year. This is the law. Any transportation cost, if you have applied, if the employer employed an employee out of the working station, out of duty station, if you're employed out of Dar es Salaam, you came from Mwanza to come to work with an employee in Dar es Salaam, and there was an agreement that if you come to Dar es Salaam and you're coming from Mwanza, then they should give you the transportation allowance. And section 43 is called the repatriation allowance. But also do not forget the certificate of service, where it mentions that this employee has worked. But as much as the law has provided for the retrenchment package or the terminal benefits as far as the retrenchment is concerned, but employers can also have collective bargaining agreements with the trade union, recognize the trade union with the bargaining rights at the workplace. They can have a collective bargaining that has provided for better package other than what has been provided by law. Because as I've said, this is the most lenient section under the employment regulation that favors employers, because it knows that the employer is not doing well. But you can also have policies. You know, some employers who do not even have a collective bargaining agreement, they do have policies as far as the retrenchment is concerned, or there's a loss of job for any other reason, where they provide a better package. But if the employer does not have all that, you can discuss with the employees through consultation. And that's why there is a consultation. So the employer can consult with the employees, how much can you afford to pay? So this is left between the two parties, meaning the employer and the employee, or the workers, the trade union at workplace, to discuss what will be the package that the employee will be going away with as the matter of terminal. I would like to insist on my last 2 points on issues of social dialogue. That goes hand in hand with when we talk about consultations, because the social dialogue is where the employers and the employees, or the trade union at workplace, they sit together and discuss matters affecting the employment, affecting their workspace. So social dialogue is something that we as an association of Tanzanian employers always insist, always advocate for, because with the social dialogue, you can minimize disputes at workplace. You know, there are so many matters. You look at grievances, they start slowly, they start, you know, underneath, and you think if it's not solved, if people don't talk at the workplace, then it actually escalates. And before you know it, it becomes a dispute. Before you know it, it is going to CMA. Before you know it, the employer is paying a lot. Or before you know it, an employee is unhappy, and the workplace is not a better place for, you know, for employees to work. And employer, all their concern is productivity. Their concern is to make business. And the employees also, they want to work at a place where they can also be happy and be treated fairly. So social dialogue can at least minimize a lot of disputes at workplace, and we advocate for social dialogue. We are not saying that if you social dialogue, everything you will agree, but social dialogue is important because you negotiate, you sit on the table, and you put things on the table and see what can work for the employer and what can work for the employee or the trade union who speaks on behalf of the employees as well. So at this time, COVID-19, what has it brought? It has brought a lot of questions. It has brought questions on whether employers and businesses have got good policies. So this is the time to amend policies, I will insist. It's a time for employers to amend policies. Look into your policies. Are they in line with the different aspects that are unforeseeable? What can you do to amend? What have you learned from the pandemic that probably you need to review your policy? we have seen disciplinary issues being raised at these times. You know, how are you going to manage the disciplinary issues where you need to conduct a disciplinary hearing online? You know, have you covered that in your code of conduct? Have you covered that in your staff handbook, that you can also conduct a disciplinary hearing online? You know, those are the issues that have come about. It's just that, you know, we have a limited time, but you can always consult the Association of Tanzanian Employers on different matters, including the disciplinary issues. So just to finalize, work from home. If you're working from home, employers should have a policy on working from home. What are the do's and don'ts for working from home? What kind of support an employer needs to provide to an employee in order to work from home? What about the issues of workers' compensation? What about issues of performance? This is where we see supervisors and the managers, they really need to push up their game to follow up on the employees' performance. But also, this is the time also for the employees to show how much they can work. But also, working from home has proved that employees, they even work longer than what they have been. I have been working from home most of the time, and I have found myself even working beyond the hours that I was working when I was in the office. So it is possible. Some people say, I am actually working longer because you are probably at the comfortability of home. But does it work for everyone? No. What about your workplace? Maybe you need to discuss that, you know, in your staff meetings, and you can come up with the better policies that can suit only your business, because each business is different. But also keep your workplace safe. Yeah, we have seen that some businesses are starting to come back to normality, at least half normality. But then we keep on insisting to follow the health directives from the Ministry of Health, keeping the hand hygiene, washing hands, sanitizing at workplace, and the employer, it is the obligation of the employer making sure that the workplace is safe and healthy, as I've said, because the Occupational and Health Safety and Health Act of 2003 provides for that under Section 19. Yeah, making sure that employers are actively encourage sick employees to stay home at this time. If somebody is not well, they should not force, because you don't know what they're carrying before you know that could infect probably the whole workplace. So COVID-19 has brought a lot of challenges. Certain things we have never known before. We are all learning from it, but we can learn and become better. That's the only way. You know, we can learn and become better. The laws are not such. We have the laws, but the good thing is we can sit between employers and employees and make policies that can work for us, as long as they do not contravene the law. The Employment and Labor Relations Act provides only for minimum standards, like any other employment laws that we have. So we are given a chance, employers and employees, to discuss certain matters and also amend our laws as well. Next slide, if there's any. If you wish to get in touch with ATE, that is our website, www.ate.or.tz. And I want also to tell you that, you know, you can get a lot of documents under the, you know, from the website. We have produced different documentations during this time of the COVID-19, so that the employers can comply and not getting confused on what to do. We have a guideline called an employer's guide during COVID-19, but also we had a guideline issued 2 weeks ago called working from home. So, and under that guideline, you can even, at the end of the guideline, we have even provided a sample of the policy that you can come up. So you can custom that policy, and if you need further help, we will be very, very happy to help you. But there are other labor law updates under the from the website as well. You can look at the retrenchment procedures. We have retrenchment procedures. Issues of leave have been covered also under when you look into the website. We have retrenchment procedures. I think that was the last issue issued. If you need more explanation on it, we'll be very, very happy to have. Any queries, you can write to us at info@ate.or.tz. We have COVID-19. This is a specific email that was formed to address all matters of COVID-19, and there's been a lot issued, and we'll be probably issuing very soon some of the the questions that have been asked by the employers, and even employees have been asking as well on that website. And then we'll come up with the solutions that will be provided. But specifically also, you can write to us at legal@at.or.tz. Back to you, Lucy and Angela.
Thank you very much, Susan, for that very, very enlightening presentation. Just to remind our participants, you can continue asking questions on the question and answer section, and I assure you our panelists are answering the questions in real time, so let's continue asking the questions. So our next speaker is Dr. Major Mpalata. Dr. Major Kasim Mpalata is a Director of Occupational Health and Safety and HIV and AIDS at the Trade Union Congress of Tanzania, that is TUCTA. He's a medical doctor and a lawyer. He's a medical doctor and a lawyer by training, so he's an advocate of the High Court of Tanzania. He has previously worked in the Ministry of Health and at a parastatal. Mr. Major, welcome, and we urge you to be a bit conscious of time. Karibu sana, Daktari. We'll start with a poll. Before he gives us his presentation, we'll start with a poll. The poll is popping up on your screen right now, and the question is, how many of you know about Trade Union Congress of Tanzania? If you have heard about it, just say you do. If you don't, say I don't. If you are not sure, maybe you've heard of something about that, but you're not sure, you can just click on not sure. Let us continue voting for the next 10 seconds as as Dr. Major comes on.
Thank you very much, Angela. As I wait for the polls, I wish to say the poll is there, and those who know Trade Union Congress of Tanzania are 63, those who don't know are 33, and not sure 4%. A bigger number of the participants seem to know the Trade Union Congress of Tanzania. Let me say from the outset that the arrangement of labor matters in Tanzania, just like any other country, has three players. It's the government, the employers, and the workers. This has been well articulated in the previous panelists. May I have the first slide, please? First slide. Now, on the aspect, first slide, okay. Now, since there are three players, the government, employers, and the workers are well organized in their own organization. And the umbrella organization currently in Tanzania is the Trade Union Congress of Tanzania. It has 13 affiliates, sectoral unions formed in nature of sectors, currently 13. And besides the 13 affiliates, there are other trade unions operating in Tanzania which are registered, who are not member to the Trade Union Congress of Tanzania. All the same, under the tripartite arrangement, and when I say tripartite arrangement, I mean it's in the social dialogue where the government, the workers, and the employers are involved. Usually there is a recognition of the three partners who are already registered in the country. And currently the only umbrella organization registered in Tanzania is the Trade Union Congress of Tanzania. But nevertheless, when there are discussions regarding labor matters in Tanzania, the rest of the unions are also represented despite being not members of the umbrella organizations. Now, the Trade Union Congress of Tanzania being an umbrella organization, is also the voice of the workers in the country. And it engineers the tripartite dialogue at a national level. And down at the workplace level, our unions who have direct members are in charge of a bipartite arrangement or bipartite discussions at a level of the workplace. So at national level, the Trade Union Congress of Tanzania, or TUCTA, will take charge to represent the workers in all matters related to labor. Being a voice of workers, amid COVID-19, in March, the Trade Union Congress of Tanzania, in collaboration with the ATE, the one that Susie has just been representing, made consultations in order to move the convening of the Labor, Economic, and Social Council, a statutory body which advises the minister responsible for matters of labor. So in March, Trade Union Congress of Tanzania, in consultation with ATE, enabled to convene a meeting for the council, and the council deliberated on how we should now handle this epidemic. It's an emergency, but labor is part of the society that is affected. And out of that meeting, a number of recommendations were made to the government by the Labor, Economic and Social Council, or in short we call LESCO. And just in brief, in a nutshell, most of the recommendations were around how the government should now facilitate the employers as well as the workers to make labor matters as smooth as possible, and by probably also putting in place guidelines. Currently, we do not have a guideline that will really, each employer, let's for instance, or worker will certainly come and say, now, under this emergency, the kind of life that we should pursue is 1, 2, 3, 4. It's not there. So this is one of the recommendations made to the government, and more so to the minister responsible for labor matters, to put in place a guideline that it will come uniform, will be a uniform one for all employers who are operating in their country. They may be under ATE or not even under ATE, but all employers. So TUCTA, or Trade Union Congress of Tanzania, also in that meeting spoke for the workers, in which the emphasis on adhering to the workers' rights and interests have to be taken into account during this epidemic. And therefore, you will have noted from the past presentations that a number of things have been touched on, issues relating to occupational health and safety, and the issues even relating to rights of workers in workplaces. I will, however, go to speak in two more areas, either in emphasis or in making some more further recommendation under this circumstance of the COVID-19. And having given you an overview of the Trade Union Congress of Tanzania, I will move to another area. Next slide, please. Now, the other part of this presentation that I wish to bring a message across to all the participants is in respect to occupational health and safety amid COVID-19. We all know that at the moment, the mainstay of managing COVID-19 remains prevention, and the Ministry of Health has given guidelines on that. I do not need to repeat the most important things that have to be taken into account in prevention of contracting COVID-19, as they've also been well illustrated by the previous panelists. But TUCTA at this juncture, in the light of this COVID-19, would wish to recommend further on the following. Employers to also extend the use of PPEs. PPEs are personal preventive equipments. I am aware, as all participants have heard from Susan, who presented on behalf of the employers, the efforts that have been made, and I'm very grateful for that. It's really something that deserves some commendation on that. But we all the same, it's a recommendation from us that let's also, as we extend these measures to the members of who are working, let's also extend these measures in consideration of their families. At times we do forget that the workers or employees do have their families behind who require as much protection as the workers do. So we recommend that all the time, under whatever guidelines they make, they should remember behind their employees or workers are their families. The other thing that we want to recommend, over and above of all what has been explained by the previous panelists, is that the arrangement even in the office. You may recall Susan also mentioned this, and she said in places where space is enough, it's difficult, you have maybe to make some rearrangement by probably using the number of staff and the like. We also propose that at times, even that is not enough. So in offices where people stay in one office in groups, there should be some kind of consideration, probably keeping some screens of a table, which is two or three people. In between the two workers or employees, there can be a screen, and simple screens like those made of plastics as part of, enforcing our means for prevention of infection of COVID-19. The other thing that we are, as TUCTA, and probably this is more to the workers also, is that we wish our workers also know that there is a responsibility placed for the employers and for the workers as well under the Occupational Health and Safety Act. And where we fail to meet these obligations as workers and employers, then the referee or the overseer of these standards is the Occupational Safety and Health Authority. So we are encouraging the workers, wherever they are, where they feel that measures are not being employed well by the employers or by even the government, because the government is also an employer, they have then an opportunity to seek help from OSHA. OSHA are in charge of the custodian of the health and safety at workplaces, so that they can intervene and help. Next slide, please. Yeah, together with this, where we also have TUCTA needs to hear, and in this webinar, we wish to make a plea to the government and the public. In my previous slide, I had spoken of OSHA being in charge of overseeing the necessities on occupational health and safety at workplace. Now it's our plea that in order to ensure that we are seriously taking this matter of prevention of COVID-19 in the workplace, the inspectors, there are inspectors under the Administration Department of Labor, and there are inspectors under the Occupational Safety and Health Authority. We request them to keep special attention in their role of inspecting workplaces to ensure that all the measures, the current measures that are being proposed to manage COVID-19 in the workplace are really followed and adhered to in the workplace. We are human beings, and we sometimes definitely need a bit of a follow-up, a bit of, a bit of a carrot and a stick if need be. So the ones who can do that are the inspectors. So them to keep that attention. We are also emphasizing as an umbrella of organization for workers that the workers should ensure compliance of preventive measures, even in the workplace as well as at their homes. Workers are under the Occupational Health and Safety Act, Section 83, given responsibility, which even attract sanctions in case they fail to abide. And we are emphasizing this because we are part of the people who are affected, and therefore we should really play a part, even at our personal level or even collectively, that in our, be it at the office or be it at home, wherever the working environment will be, we have to ensure that there is a compliance to preventive measures. The employers also, they have the obligation. I understand that Susie has made it very clear on that, and I need not overemphasize, but those obligations have not just to be said, they have to be seen done in the workplaces. This is our emphasis as your partners, Trade Union Congress of Tanzania. Next slide, please. Now, COVID-19 has brought problems to all of us, and the rights of workers have really been impacted. And since there is this impact, we have positions as workers, representative workers, that the workers' rights should be observed, such as remuneration, working hours, leaves, severance pay, social security contributions. Well, I know Susie has spoken very well there. She has made a lot of employers' sentiments and the like. All the same, we have to ensure that the rights are not tempered in any way. So let's keep it that way. And I hope ATE will live to their words that have been clearly come out of the 80s panelist presentation. The other thing, which is also has been very well emphasized by Susie, the consultation. If we want harmony, you want everything to go smoothly, if you want high production, then you have to do three things. First one, consultation. Second one, consultation. And third one, consultation. If you do that, and thanks to Susie who has already also made a great emphasis on that. And the other thing that we want also to bring as a light to the participants and the workers in general, that there is a right of compensation for those who contract or suffer from COVID-19, especially the health workers, because you are also the representative of the all workers, including the health workers. The health workers who contract COVID-19 under the workers' compensation, ready together with the occupational health and safety rules of notification. Though COVID-19 is a novel disease, but it can be inferred to this list of occupational diseases as a disease that can attract compensation. So those who suffer, it's high time they should not just sit behind, but should start moving the use of this law. Next slide, please. Just on more on the rights of workers, just correctly, as Susan has put it, that the labor laws provide for minimum standards. And, but then there is, together with this provision minimum standard, there is a parallel provision that there should be a consultation, dialogue, in order to improve the standards through collective bargaining agreements. And collective bargaining agreements are the domain of the employers' organization, the employers and the trade unions. Now, I want to emphasize the importance of collective bargaining agreement. We have already seen under COVID-19, workplaces where they have collective bargaining agreement have fairly said smoothly in respect to on how to deal with the impact that is arising in respect to the rights of workers. Where there are no collective bargaining agreement, there are problems. So this presentation here is just meant to encourage workers to dialogue with their employers and enter into collective bargaining agreements. I know the dialogue involves the employers and the workers, but you know, when you are working for the improvement of labor standards, the one who gains more is the one who should be starting the ball. So I'm emphasizing for the workers to just wake up and make sure that wherever they are, they join the unions so that they can negotiate with the employers to improve the labor standard, the minimum labor standard, which are currently provided under our labor laws. All right, under COVID-19, we have, well, despite all the measures that are being taken, that retrenchment and or termination probably should be the last resort, but we have witnessed that there are people who have been retrenched and some have been terminated currently, leave alone those who have gone for leave, for unpaid leave. Now, for those who have been retrenched or have been terminated, Instructor wishes to advocate to move again for the use of the unemployment benefit, for which is now under National Social Security Fund. This benefit is applicable to those who are retrenched, those who are terminated, and it gives a bit of cushioning of life in the times. And I will share with you all these legislations which I'm referring for you to see the relevant sections and the relevant rules to apply. So we are encouraging our workers to start to consider those who are being affected during this time to also consider seeking refuge for their right in the NSSF fund. Okay. The other thing that we have not observed it much, but we think it may come, is the issue of discrimination of workers who are affected or infected by COVID-19. Hello?
Hello, please summarize in the interest of time, because we still have another speaker and we are running out of time. So just summarize in 1 minute.
And this is the last slide.
Yes.
So we are underscoring the importance of non-discrimination to the workers who are affected, and also for those who are working at home, the employers should provide equipment. Just to end my presentation, I wish to appeal to all of us that we are, be it employer, government, or worker, we are all in a burning house. And the best thing we can do to rescue this house under the COVID-19 is to work together, in brotherly, to work together, in consultation, and to work together in cooperation. Thank you very much.
Okay, thank you very much, Dr. Major, for a very insightful conversation. It's good to see that the writers also is an organization that's actually protecting workers. And I think that you elaborated the most important things. Without any more delay, I'll be introducing our next speaker, who's Honorable Mpule Usekelege. So I will just briefly tell you about Honorable Mpula. So Honorable Mpula is the zonal officer in charge of the CMA, which is the Commission of Mediation Arbitration in Dar es Salaam zone. He has extensive experience in arbitration of complex labor and employment disputes in Tanzania. He's an advocate of the High Court and subordinate courts. So welcome very much, Mr. Mpula, and we're looking forward to learning from you.
Thank you, Lucy, and all the panelists and the participants.
Yes. We will start with the poll. So, like always, there's a poll, and the poll is, do you know the functions of the Commissioner of Mediation and Arbitration? So if you do know what the functions of the CMA are, please select yes. If you don't, say no. If you don't know, say you do not know. 30 seconds for you to respond. And after the 30 seconds, Mr. Mpula will continue.
Yes, as I think the results are out now, it appears almost 81% are aware of the functions of the Commission for Mediation and Arbitration, while 19% are not aware of the functions of the CMA. But it is of no doubt that the 19% will be taken on board after this presentation, so that they also know the functions of this commission. Well, I'll be taking you through, actually, generally, CMA amid COVID-19. But before going into any further details, it is very important for the participants to know what is this CMA. And I think this will bring the answer even to those who claimed to have not known the functions of the CMA. Actually, under the law, the CMA is an independent institution or department of the government, which is vested with powers to deal with labor disputes in mainland Tanzania. Actually, it is the only institution with such exclusive powers. And I insist on that because it appears some of the employees do not know the exclusivity of this institution, to the extent that at times when they face labor disputes, they knock to the doors of the district commissioners or regional commissioners and sometimes the ministers. By so doing, they waste a lot of time, while disputes under the law have to be filed in the CMA within a limited time, that is 30 days for disputes based on termination, while other disputes, it is 60 days. So I urge to all the employees not to waste time by knocking the doors of other offices or trying to settle their dispute through the politicians. It is very important to go straight to the CMA so that they don't lose their rights unnecessarily. Let me go quickly to the functions, actually the core functions of the CMA, which are also provided under the Employment and Labor Relations Act. We have got two core functions of the CMA, and the first is mediation of labor disputes referred in terms of any labor law. So mediation is actually our first and the foremost function to bring about industrial harmony. And considering this COVID-19, our emphasis is on that process of settling the dispute through mediation. But where mediation fails, it's where the second core function comes in, and that is arbitration of the dispute after failure of mediation. And that comes in where the parties actually have not agreed to settle the dispute, or sometimes where the labor court refers the dispute to be determined by arbitration. Now, having known the core functions of the CMA, it is also important to take you through what are the common disputes brought to CMA amid COVID-19. Actually, there is a good number of disputes listed in the referral form, many disputes which may be brought to the CMA by the employees or employers or trade unions, for that matter, in employers associations. But commonly, and currently, I must say the following are among the common disputes amid COVID-19. Allegations of unfair termination. It appears a lot of employees have been facing this dispute after being terminated by the employers. And the second is retrenchment. As it has been explained by the previous panelists, and especially Advocate Susan, this is one of the disputes which is coming now and then, and we are receiving a good number of disputes on that. Also, non-payments of salaries. That is also one of the disputes which is coming up, and the number is ever increasing day by day. There is a claim of a dispute on leave without pay for many employees, and breach of contract, to mention a few. But other disputes, as I have said, are listed in the form number 1, which will be provided to the participants after this presentation. I believe they'll be available for everybody. Now, I said in my introductory party that our emphasis is on mediation. And I think I should touch a little bit on the difference between mediation and arbitration. Just in a summary, it should be known that mediation is simply a process whereby an impartial third party, we call mediator, is appointed to facilitate the parties to the dispute or the disputants to voluntarily and amicably settle their dispute. To the contrary, arbitration is a process which comes in, as I have said, after failure of mediation. Hence, an arbitrator is appointed to determine or to decide the dispute by making an award which is binding upon both parties. Now, considering the need and, of course, the emphasis of the CMA to mediation, I think it is important to share a few advantages of mediation over arbitration. The first and foremost is time saving. Mediation takes a very short period of time, and also it is cost effective. Actually, there are no cost implications in mediation process. This is because one does not necessarily need to employ an advocate or a legal representative whatsoever. So simply the parties to the dispute may come and amicably settle their dispute by the assistance of a well-trained mediator. Also, mediation encourages negotiation to at least try to minimize the claim. I have just been updated as I was waiting for this time to present my presentation. I got good news from my director of arbitration from the headquarters. We were dealing with one of the big disputes which has come in amid COVID-19, involving 2,900 employees who have sued a company called Fabric and Production East Africa Limited. Actually, the trade union called it TWICO instituted that case. And luckily, that, and I'm glad, actually I'm proud to say my institution has concluded that dispute through mediation. And amid this COVID-19, actually, I can even air out the outcome that parties, that is the employees and the employer, have agreed a salary cut by 60%, at least during this period. So I strongly emphasize that mediation is the best process to go through this COVID-19, because it appears to have caused a kind of economic crisis. Having said that, I think I should also take you through to what are now the CMA strategies to deal with the increasing number of labor disputes amid COVID-19. I am the officer in charge of the CMA in Dar es Salaam, and I must say a little on what has happened from the time when the first case was reported about COVID-19 in Tanzania. We have received up to this moment a total number of 1,075 disputes. That is the increase by almost by 56%, and the number is increasing. This means the disputes are still going on, and the employers and employees are not at peace over there. So we have put in place some of the strategies to deal with this increasing number of disputes in the CMA in Tanzania. The first and foremost is motivation and encouraging settlement through mediation. I have said that in my introduction, and that is our emphasis to have the dispute settled through mediation. But also the CMA is determined, and actually it has been doing that, conducting what we call crash programs, and sometimes we call BRN, or big results now. That is done by actually identifying places with a big number of disputes and gathering a good number of mediators and arbitrators to actually go where the disputes are many and determine or settle them all within a limited period of time. So this is the moment, and actually we are busy strategizing that and putting that into practice so that the ever-increasing disputes are settled within time, and to avoid any adverse effect to the Tanzanian economy generally. Also, we form what we call task forces, as I have said, of mediators and arbitrators, and they migrate them to the places where disputes, or there is a large number of disputes in Tanzania. Apart from that, we also encourage proper parties to attend to a mediation process. Why I say proper parties, I mean the employer and the employees. As I have said, mediation process, for instance, does not necessarily require legal representation. And especially for this moment, to avoid unnecessary costs, it is important the parties to the disputes to attend mediation and settle the same. Like the example I have given, imagine how positive it is to settle a dispute involving 2,000 employees within a short period of time. That has saved a lot. So we encourage proper parties to attend mediation. Why do we believe that it is important to settle disputes through mediation? This is because of the effects that the CMA awards have to both employers and employees, and maybe the trade unions and the employers association. So I'll quickly take you through the effects of CMA awards and modes of execution, which maybe some of the participants would not love. And due to that, I again insist mediation process to be the best mode to settle the dispute. In Tanzania and under the labor laws, the arbitration awards have the following effects. One, it binds both parties. That means there is no negotiation. Once an award is made, then it is mandatory for the parties to comply. Also, it is not appealable. That has been, actually has called for some opinions as to why CMA awards are not appealable. That is the law. So once you are punished or you are ordered to pay compensation, then that remains as it is. Maybe the only avenue is to apply for revision, but the judges do not alter. They simply quash and maybe remit the matter to be tried again. But the CMA awards stands and are executed as they are. The third effect actually is it is executed by the High Court Labor Division. That means when an award is made, the law requires the Labor Court to execute the same. And here it is important for participants to know the modes of execution, which are not that economically friendly to employers. For instance, an award can be executed by way of attachment and sale of properties. Imagine amid COVID-19, then you lose a case in the CMA, and actually your properties, vehicles or houses or whatever, may be attached and sold for the purpose of payment. So that is an adverse effect of CMA awards after being executed. There are also garnishee orders where accounts, bank accounts are held. And actually, there is no way you can escape if an award is made and you are ordered to pay a certain amount. If that amount is in the bank, then the court has a jurisdiction to order such amount to be withdrawn and the judgment creditor being paid for that matter. But also there is this bad one, and of course, one may not like it. Imprisonment of the award debtor as a civil prisoner, actually. You may find directors or whoever who is the owner of a certain company may be imprisoned simply because of failure. And that has also another bad effect of the possibility for the company to be declared bankrupt. And that is, I think, a bad one. So it is the CMA's emphasis that during this period of COVID-19, our emphasis is on settling the dispute through mediation. And it is, again, very important for the participants and actually employers and employees to know there is nowhere you can go other than knocking the doors of the CMA within time so as to settle the dispute within such a time provided under the laws. So having presented in the manner I consider quickly but straight to the point, I believe the participants and the stakeholders have catched up what is important as far as dispute settlement in the CMA are concerned. Thank you, Lucy. Over to you again.
Thank you. I think Angela will be taking you on the Q&A session.
Thank you to all our panelists. I think their presentations have been very enlightening. I now consider myself an expert in Tanzanian law, despite the fact that I'm based in Kenya. But on the basis of these presentations, I think I can cross over and come and set up my practice. So there are several questions. Some have been answered in the Q&A section. And there are some that we had gotten via email previously. And this one, I think I'll direct it to Dr. Major. So you have been told, you are an employee, you've been told by your employer to work from home, you're seated on your desk with your laptop, then there is a power surge, then your laptop fries, you are typing, your fingers get burnt. So whom should you sue? Because ideally you've been injured while working from home, and your contract of employment stated expressly that you need to be working from work, like you need to sit at your desk and work there, but your employer told you COVID has come, work from home. So whom should the employee sue?
Thank you, Angela. In this respect, the employee can sue the employer, and they can sue the employer under the Compensation Act, because if you start working at home, the definition of for compensation is any disease or injury arising out of employment, and the home is an extension of employment. In fact, law cases have already settled that. If you contract a disease or get injured within the vicinity of, or during the course of doing the job for which you are employed, then you qualify for compensation. Thank you. You sue the employer.
Okay. We also have another question, and this will be directed to Susan. Both you and Major and all the speakers have emphasized on the issue of consultation, and more consultation, then after that, more consultation. So you have done all that with your employees. You are proposing a 60% salary cut. Then the employees refuse to maybe sign that agreement, or they refuse to accept the pay cut. What options does the employer have?
Yeah, thank you, Angela. Remember in my presentation, I said that the Employment and Labor Relations Act really, when you look at Section 28 and the Code of Good Practice as well, really emphasize on the measures that employers should look into in order to minimize, the retrenchment. So reduction of salary during these times, it's one of the measures. Rather than employees to lose jobs, that's why employers have been looking into reduction of salary in order to sustain business and also to be able to bring them back to normality, if there will be any normality, in the future. Therefore, and that has happened, so whoever is asking, that has happened, that employers have been suggesting that the business is not doing well and you can clearly see that we do not have business, therefore we suggest for a salary cut. But again, the same law, Employment and Labor Relations Act, it provides for how much an employer can also cut, because people need to survive. But if at any case, because it is consultation, if at any case an employee or employees or a trade union is not in agreement with the salary cut, then it will leave no option for the employer to go to the last resort. That will be retrenchment. So for those who would refuse, then the employer will have to follow for procedures. Now you embark into the procedures that have been provided by law in order to retrench, because the employer has to sustain business. The employee is not able to, is not in agreement on the salary reduction, and therefore the retrenchment will be the only option for the employer. However, I insist again, the employer must follow the procedure provided by the law.
There's one final question for Mr. Mpula. You have, in your presentation, you had said that there's a time limit. If it is not to do with termination,
yes,
you have to file within 30 days. And if it is to do with termination, you have to have filed within 60 days. Supposing supposing somebody went to court, or they went to the politician first before they came to the CMA, then the 60 days have lapsed. Will you still entertain their dispute? That's number one. And then number two, do you entertain does the CMA entertain all labor disputes? Or there are others that if you present your dispute, the CMA can say, this is not, we cannot handle this one, go to court?
Okay. Actually, in my presentation, I have clearly said that under the law, and I think I should start with the second one, then I'll finalize this with the first one. The CMA entertains all labor-related disputes. So by saying all labor-related disputes, it means they are provided within the Employment and Labor Relations Act and its rules. We do not deal with disputes under Arbitration Act because that is not a labor dispute. There are some of the employees who raise claims, for instance, of social security claims, social security funds like NSSA. We also do not have powers and jurisdiction to deal with such disputes. So saying all labor disputes includes those which I have mentioned, but in addition, we have the labor torts, we have breach of contracts, and several other disputes which are found in the referral form, and they are all listed there. Coming to the time limit issues, if I heard you correctly, you said, what if one chooses to go or to see a solution to his dispute to any political leader or any forum other than the CMA, and the time limit provided by law is over? I must emphasize on this point that that is not one of the good reasons that I was late to file a dispute in the CMA, because maybe I went to the district commissioner or to the regional commissioner or to a certain minister. This is because those other political leaders do not have powers under the law to deal with labor disputes. So one goes there at his or her own risk. And we have this common saying in law, ignorance of the law is not a defense. So it is of paramount importance for one to quickly go to the CMA within the time that I have mentioned. That is to say, for disputes on allegations of unfair termination, then one has to file within 30 days. While for other disputes, I emphasize, one has to file within 60 days. Otherwise, and as of now, it is to the best of my knowledge that even the court, the High Court, and even the Court of Appeal have made strict decisions regarding time-barred disputes. There is one of the authority, a strict authority, which requires a person who files a dispute out of time to account for the delay of every single day, and that is difficult. So I encourage again the employees or the parties to the dispute to file the same within time. Thank you, Angela. Over to you.
Thank you very much. Once again, I would like to appreciate all our attendees. So we are pressed for time, but we can take just one live question. Pascal Kamala, your hand has been up since the beginning of this presentation. Pascal, can you hear me? Pascal, if you have a question, we can give you maybe 1 minute to talk to us, ask your question, or maybe give your comment. Pascal Kamala. Is there any other attendee who would like to maybe give a comment? You can raise your hand. You can raise your hand through the participant section, then I'll see. Well, it seems, you know, as a teacher, when there are no questions, you did a very good job. So you can continue typing your questions in the question and answer section. Our panelists are looking at them and they will respond live. So what are the takeaways from this webinar? Over to you, Lucy.
Okay, thank you very, very much to all the panelists. It's been a very interesting and engaging session, and thank you for all the participants who took part in the Q&A section. I believe most of the questions have been answered. So quickly, I'll walk you through the key takeaways. So if you've forgotten anything we've discussed in the last 1 hour and a half, 2 hours, you should remember these things from the panelists. So if you could please put up the slide so that we can remind people what they have learned today. So from Maridadi, it's important to note that Tanzania labor laws protect employees under employment relationships. I think he clarified this, that there's a difference between a worker and an employee, and why it's very important to ensure that your employment is under employment relationship for you to be protected under the employment labor laws. Another thing that he mentioned is that international labor standards provide solutions for most labor challenges during this time. So if you're thinking of, okay, how do I sort a certain problem, then you should definitely look at the international labor standards for some guidance. In terms of what Susan taught us today is follow government directives. The Ministry of Health has been issuing a number of directives, so make sure you follow them. So if you have to put hand sanitizers and all those equipments, make sure you have them. Compliance is key. So just because there's COVID, you're not suddenly not supposed to follow laws. So you should ensure that you're following laws, especially when it comes to retrenchment and anything that you do. Consultation is key. So communication. I think all the panelists have emphasized this, that it's important to communicate, not to make unilateral decisions, involve your members or your employees during this time to come up with a mutual agreement. In absence of law, have policies. So we've seen that the law doesn't cover everything. So it's advisable for you to have policies in place, which will help your employees know what to do, and especially when it comes to work from home. And then Dr. Major has talked to us about employees' rights. And he says that he recommends that employees have the right, or he urges or reminds us that employees have the right to personal protection equipment at the workplace and at the homes. He advises that you should also give this equipment to people, the staff members' family, because if you protect their family, then you automatically protect the employees. Another recommendation from Dr. Major, that workers who contract COVID-19 in the course of work are entitled to compensation. I think he said this, that the Workers' Compensation Act does provide compensations for anybody who is injured during work, and COVID-19 is not an exception. Something else that he told us is workers and trade unions should always negotiate with employers on collective bargaining agreements in order to improve the employment benefits. So if you want to have good employment benefits, he urges you to go through collective bargaining agreements. And last but not least, Mr. Mpula told us time filing of disputes. You have 30 days to file a dispute if the dispute is in relation to unfair termination, and you have within 30 days and within 60 days of any other dispute. So make sure you file the dispute before the time has lost. So don't go to the DC, don't go anywhere else, just go to the CMA. And then the other two takeaways is labor disputes should be brought to the CMA. I think we talked about this a lot. So no DC, no regional commissioner, and mediate. I think he's told us the advantages of mediation. So it's important to mediate because it's free and it saves times, and it still, leaves a good relationship between the parties. So I think those are the key takeaways, as far as I think that's the most important message that our panelists would like for you to know. So I would like to straightly go and thank all the people, all the participants who have been with us through these 2 hours. It's been an interesting session. I hope you have learned as much as I have. Thank you for taking part. Thank you for logging in from wherever, Facebook or YouTube or Zoom. We will be doing another session on finance and tax, so we will share that once the information is done. We'll also be sharing with you all the resources and materials. So if you did register, we'll be sharing all that information via your emails. I'd also like to thank you, the panelists. You've been amazing. I think you're all teachers because you've done a really amazing job. I think it's it's testament that there's not so many questions. I think you've covered the crucial points during this time. So thank you very much for being, taking us through this and taking time to do this, especially that you have very busy schedules. And last but not least, I would like to thank our supporters, Africa Law Tech and Anglo Creatives, who've been working tirelessly to make this happen. So Angela, Linda, Victor, Ken, Leslie, I think it's been amazing working with all of you guys. And thank you for putting all of this together. And yes, that is all from me. So if anything, during this time, my last comments will be stay safe and take care. So over to you, Angela.
So I can see that several attendees have raised their hands. I will give one person 30 seconds to give us a comment. Frida Shirima, can you hear me? Can give us your comments or comments in just 30 seconds, Frida? Avitas Rugakingira. Avitas. You can give us your comment?
Her mic is muted. She has to unmute it. Maybe that's what.
Well, I think the universe has decreed that we are not going to take any live comments, but to all our attendees, we really appreciate you. We appreciate you for coming. At the end, once you leave this meeting, there'll be a pop-up survey. We humbly urge you to just take 5 minutes of your time and give us feedback, because that will help us enrich the experience of future webinars. Then all the materials that have been referred to will be shared via email to those who had registered. As we leave, I would like all the panelists to be camera ready so that we shall take a virtual group photo. You can smile for the camera as we exit this meeting. We shall take a screenshot that shall be sent to all of us. Susan, smile for the camera and wave. So thank you once again. Asanteni sana kwa kuungana nasi. Hadi wakati mwingine, kwaheri from Africa Law Tech Association hapa Nairobi, Kenya. Thank you and goodbye.